Welcome back to the Morning Show here on Arise News. For a quick look at the import of the 2019 Nigerian Bar Association Conference, which took place here in Lagos, we are now being joined by Paul Usoro, Senior Advocate of Nigeria and President of the Nigerian Bar Association. Good morning and welcome to the Morning Show.
Good morning and
thank you for honoring our invitation. First, let me congratulate you on the successful MBA conference.
Thank you.
Under your leadership.
Thank you.
One major issue at that conference was the rule of law. It was something you focused on in your welcome address, and then for the first time there was a rule of law symposium, a special plenary on that particular subject.
That's right.
Now, in Nigeria, we've been having this controversy since the last MBA conference about rule of law versus national interest. So which should come first, and are there circumstances, under your view, when national interest should be, placed above the rule of law, and rule of law can be, subordinated to national interest?
Okay, I think the way to answer that question is to understand what rule of law means. Very basic. It simply means governance according to laws. Now, that presumes, when you're talking about national interests, that there are certain laws that also govern and direct national interests. And so if you're talking about national interest and the rule of law, what the lawyer wants to see is that the national interest that you're projecting accords with what the law says. And I'm not aware of any law that says, except in the Constitution, when it says, for example, that you could abridge the fundamental rights of a citizen under certain circumstances. But outside of that, the general principle is that you must always govern according to the rule of law. And even that abridgment would have to be in accordance with the rule of law, which means there is a law that stipulates this is what you need to do. And you must comply with, you must follow what that law says. So, in strict terms, there is really no conflict between those two. It's simply a misunderstanding that some people have that presumes that national interest overrides the rule of law. National interest must subordinate itself and must be in accordance with what the law says.
But in a country like Nigeria, with our long history of military rule, you can see why this kind of confusion might occur when the executive has quite an overbearing influence on every other arm of government.
No, I can understand that. Sometimes the people who say these things, they're not lawyers. But I also concede sometimes you have lawyers who misdirect some of those who say these things. But maybe because of our history and maybe because of our penchant sometimes to utilize shortcuts, which sometimes ends up being very expensive, we tend to think that it would make sense to abridge the rule of law and that national interests is not subordinate to the rule of law. But the position is that everything really must come under the rule of law, including national interest. And if you're going to abridge fundamental rights, for example, it has to be in accordance with what is provided under the law.
Absolutely.
So that's the basic position as far as rule of law is concerned.
Well, I mean, one other major issue is the independence of the judiciary. Will you say that the judiciary in Nigeria is independent, or you think that there are certain reforms that can strengthen the Nigerian judiciary, since it's the last hope of the common man, as it were?
That is correct. Now, is the judiciary independent? In literally all crimes, you find that there's always an encroachment on the independence of the judiciary, even in the advanced countries. And that's why we have to be vigilant at all times as far as the protection and the advancement of the rule of law is concerned. Now, talking about Nigeria in particular, you could talk about the independence of the judiciary from two perspectives. You can talk about it in terms of funding. You can talk about it in terms of the independence of mind and thoughts of the judicial officers themselves. Funding, the critical issue as far as funding is concerned is you find that more prevalent in the states, at least at the federal level. They're able to go to the Senate, defend their budget, and they have direct allocation of funds. But in the states, you still find that the judiciary has to go cap in hand to the executive, to the governors, and really it is at the pleasure of the governors that they have whatever they need. And that stifles development. I will explain how that impacts on the independence of the judiciary. It impacts in multiple ways. It impacts, for example, in the capacity of the judiciary to develop infrastructure that would enable access to justice. Let's not talk about whether he who pays the piper dictates the tune, but let's talk in practical terms, some other areas. The fact that the judiciary does not have the funds, it's not given its funds, impacts the infrastructure which is required for the administration of justice. And because the administration of justice is affected, the access to justice by the citizens is also affected, which is an erosion of the rule of law. That is only one aspect of it. There is, of course, the other aspect of it, that there is the perception, true or false, that the idea that somebody has to fund you could also be used as a leverage. And it makes it difficult for that other person who is being funded to be as independent, particularly in matters where the person funding has an interest. So that is another aspect of it. You could talk about independence of the judiciary in terms of the independence of thoughts. You find that increasingly the executive arm and its agencies, they have a certain mindset, particularly in matters that they're interested in. And they would wish or they expect judgment to be in a particular way. And sometimes when judgments don't go that way, there is always the tendency to malign and to destroy the reputation of the judiciary. Now, in our own climates where you live in fear that you never know when the jackboots might come for you, it's understandable that judges would also be looking behind their shoulders to see, is this agency of government or that other agency interested in the matter that I'm handling, and how do they want me to determine this matter? That, of course, erodes the independence of the judiciary. It destroys the rule of law. And so in Nigeria, those are the elements that we have to be conscious of. Those are the things that we have to fight constantly to make sure that the independence of the judiciary is protected. And the interesting thing about it is we're all endangered when judges do not have independent mind. It affects all of us. It affects even those in government. And by the way, they'll get out of government sometime and they'll need an independent judiciary. So from that perspective, independence of the judiciary is a key issue. It's something that we should look at seriously, take seriously, and the Nigerian Bar Association will continue to talk about it and to emphasize this issue. A few of the points
that you just made here was said by the CJA and Justice Tanko Mohammed at the NBA conference with regards to independence of the judiciary, them being beholden to the executive at state level. But inevitably, this issue has reoccurred in the minds of Nigerians with the judgment read by the Presidential Election Petition Tribunal. Now, we all heard the effusive praise that lawyers there gave to the five-man panel. But what is your take on that judgment?
Well, first of all, the principle of a lawyer, a proper lawyer, is that you do not comment on a matter that you are not fully seized of. In other words, you have not seen the documents. I have not seen the processes, and I've not even read the judgments of that panel. So it would not be right for me, whether as Paul Usoro or as the president of the Nigerian Bar Association, to comment right now in regard to that judgment.
But I had to ask you.
Not a problem.
What do you think of our country's human rights profile? the special rapporteur, you know, of the UN Human Rights Council was in Nigeria recently, and in her preliminary report, she didn't have very nice things to say about, you know, Nigeria. But human rights being a major part of the rule of law, what do you think of the country's profile?
Yeah, there are quite some things that need to be done that would improve that profile. Let me not necessarily go on the political side, so to speak. Let me talk about the ordinary person who might have been locked up in detention and has no access to the courts. And I have heard stories, real-life stories, of, for example, people who have been detained and their matter is to come up in courts and they're awaiting trial. Their matter has not even been decided at all. Maybe they're even waiting, they haven't even been granted bail. And they come into courts in recent times, and maybe there's a high-profile matter that is being heard by the courts, and their matter is adjourned and repeatedly adjourned. And they might stay in detention 1 year, 2 years, 3 years, simply because the court is not available to hear them. Now, that is a degradation of the rights of the individual. And there's no way we can look good from a human rights perspective when there are cases like that. We can talk about even those other ones, the cases sometimes that security agencies take undue liberties. They pick people up and they lock them up, and they might be there for a very long time. That doesn't speak well in regard to our respect for the human rights of our citizens. And there are different other areas you can look at that we definitely can improve as far as fundamental rights or the human rights of our citizens are concerned. Plenty of it. And yes, that necessarily also ties into the principle of the rule of law. Because rule of law, one of the components of rule of law, of course, as I mentioned, is access to justice. And access to justice has different facets. It can mean access in terms of the financial capability. If you do not have that financial capability and you're not able to access justice.
Well, Mr. Usoro, if we just hold your thoughts, we'll take a short commercial break and then we'll come back. We'll take a break now. We'll be right back. Stay tuned. You're still watching The Morning Show here on the Arise News channel. And with us in the studio in Lagos is Paul Usoro, Senior Advocate of Nigeria and President of the Nigerian Bar Association. Mr. Usoro, you were talking about human rights, the human rights situation in Nigeria, and you've talked about people being denied access to justice. Yes.
Yes, and what I was explaining, the last bit I was explaining was that it ties in with the rule of law, because those components are actually parts of the rule of law whole. And so if you have those challenges as far as human rights is concerned, then of course you also are having an erosion of the rule of law as far as Nigeria is concerned.
I want to talk to you more about access to justice from the perspective of legal aid, which I know is one of the things that was discussed at the NBA conference. A lot of people don't even know that they can access legal aid. What was discussed at that conference? And because the whole theme was facing the future, what is the future of legal aid in Nigeria?
There is let me put it this way, it does have a future. But you know, legal aid depends on funding as well. So sometimes you have paucity of funds, starvation as far as funding is concerned, and you may not have its impact as well as it should. You may not feel its impact as you should. The other thing which is encouraged, and the NBA encourages that, is actually pro bono services. The firms that could afford and that are well-heeled, it could be part of their, what is known in corporate circles as CSR. It could be part of their giving back to society, that they would take on some pro bono matters and handle them. And you find most of those pro bono matters mainly in the criminal matters, people whose rights have been infringed. And by the way, infringement of rights, they do not necessarily have to be criminal matters. You might find, and this happens in gender violence as well, and you find instances that the people might need that assistance, but they're not able to afford it. So we encourage firms to do it. And what we're also trying to do, as far as the Nigerian Bar Association is concerned, is also to build our capabilities as far as pro bono matters are concerned. And that is how you can actually impact the society in terms of legal aid to those who are needy and who really need that assistance or support.
Well, I mean, as Tundu pointed out, the theme of this year's conference was facing the future. Now, what are those challenges that the lawyer of the future in Nigeria, in terms of practice, should prepare himself or herself for, particularly with regard to technology, which is, beginning to play a major role now with some law firms even using robots, and depending heavily on technology. Do we need some kind of changes to the curriculum in Nigerian law faculties or in the law school to better prepare that lawyer of the future?
Actually, in terms of curriculum, yes, that needs constant re-evaluation because, of course, society is dynamic; it's not static. And some of the things, some of the features that we were used to when we joined law practice, they are not the same as what we are used to now. I think there are various aspects of that technology challenge that, from a legal perspective, one needs to look at. You can look at it. Let me go to the one that affects even the common people, and that is having to deploy technology for the purposes of administering justice in the courts. That is something that we don't have. I can't even say we're struggling with it because I can't see any conscious efforts to move from the manual, yes, to the technology age. And it is only if you have experienced it in some other jurisdiction that you would see the benefits. That not only does it fast track the hearing and determination of cases, which also plays into the access to justice theme of the rule of law, but it also actually aids in terms of preserving the health and longevity of the judges themselves. So you can look at it from different dimensions. But even from the perspective of rule of law and technology, it makes a lot of sense that we should actually start advancing our judicial system into the technology age. We should deploy technology to fast-track things. But that is only one aspect of how technology, looking at it from the future perspective, how we need to deploy technology. Everything is more or less globalized now, and legal practice is not an exception. And so it's not unusual for you in Nigeria to have clients who are in Singapore, in different other places, or to be working with your counterparts that are in London or in New York, etc. And if you are not technologically savvy, it's very difficult for you to be in that league, to play in that league, to work in that league, to do things efficiently. So that's critical, and you still find a lot of firms and practice that do not have that technological ability. And it's important that we all learn and understand that the world is moving very fast as far as that area is concerned. Now, let me go to the area that you talked about, robots. Will they replace human beings? Not likely. Because, you see, in legal matters, you don't have a one-size-fits-all solution for legal matters. It all depends on the facts of a case, and then you customize the solution to the facts of that case. Now, for robots, essentially, It's what you feed into them that they give you back. So you definitely would need that intelligence, that human intelligence, for you to decode exactly the strategy that you need to deploy for this particular case, because cases are different. And by the way, we're not very good, very strong in strategy as far as Nigerian lawyers are concerned. But more often than not, you win or you lose your case depending on the strategy you deploy. And you really can't depend on a robot to give you that strategy. You have to do the thinking, you have to understand the facts, you have to differentiate it, you have to know exactly that pressure points that you need to apply for you to be able to win that case or for you to be able to overcome certain things. That's one aspect of it. Don't also forget, and now I'm talking about the commercial lawyer who is even in litigation. The commercial lawyer who is in litigation, unlike perhaps the general litigator, the way he looks at things is more that litigation is a means to an end. It's not an end. In other words, it's not simply about winning a case. It's about, if it's a business transaction, making sure that you put your clients in a position of advantage. So the litigation might actually be a means for having to propel a resolution of a conflict and meeting and mutually agreeing on something that is favorable to all the parties. That needs human brain far more than that of a robot. So even when robots are introduced, and that is one point that the president of the International Bar Association, who was here as our special guest, correct, he pointed out that robots would not replace the humans, that the humans would still need to be able to program the robots. And so there is no danger there. But you need the skill, you need to have the knowledge. How do you relate? What do you need to do in this day and age of technology? And how do you deploy technology to help you advance your practice or the administration of justice? So facing the future, that is definitely an issue that we need to address seriously.
So you had this huge conference, very well attended, a broad range of speakers, but for you, what were the highlights?
For me, well, I could tell you from different perspectives. As Paul, I would tell you I felt quite fulfilled. That was as Ruben pointed out, 12,000 lawyers in one space having a conference. That was huge. We've not had that size before. And I feel very fulfilled that all the reviews about that conference, they have been very positive.
Thank you, sir.
Well, Mr. Paul Usoro, thank you very much. We've enjoyed this conversation.